advisement. We now turn to the fourth case on this morning's docket. That is case number 103532, State of Kansas v. Derek John Holt. Counsel, before you start, I did want to make an announcement. Some of the people in the audience may find the facts of this particular case not to their liking, and if you would care to just leave our courtroom at that time without too much interruption, that would be fine. Please proceed, counsel.
Thank you. May it please the court, Mr. Chief Justice, I am Richard Ney. I am arguing for the appellant Derek Holt in this case, and I would ask to reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
Thank you. I have litigated many appeals before this court, before the Court of Appeals in Kansas, before the Federal Court of Appeals. And as difficult as any of those cases have been that I've done in the last 30 years, they're all different from this one. Because in those cases, I actually had a record. I actually had a transcript of the material that I was saying was improper, that where the judge had ruled incorrectly. But I don't care.
And the rules allow for a reconstruction hearing, which you're familiar with because you were in attendance.
I was there.
You were there, and the trial court did the best it could. The state proffered and submitted what they believed their findings were from that as best they could reconstruct 4 years after the fact. And you took no opportunity, Mr. Ney, to supply a different version or to even object to the state's version. Isn't that right?
I did file that this was incomplete, that it could not go forward as a reconstruction. But I was not trial counsel, Your Honor.
I understand, but you were present at what was your role at the reconstruction hearing?
I'm not sure, frankly. Trial counsel, I certainly called the meeting to order, I guess. I filed the motion to have the reconstruction because I'm required to do so. Trial counsel was there, Mr. Fern.
Right.
And let me just read, as the court heard from Ms. Johnson about her recollection. Mr. Fern, the court asked, does that refresh any of your memory, Mr. Fern? Answer, not really, Your Honor. I don't remember that. He asks again, I do not remember that. Ms. Johnson said I did, filed a matter. And that was his contribution, basically, to the effort. As I said at that hearing, Your Honor, what can I say? Whether something happened or didn't happen, I wasn't present. And I think the case law, both in this state and elsewhere, talks about that dilemma with trial counsel. The Lumbrera case talks about when trial counsel and appellate counsel are different, that really there is a different standard. The Stacy case, the federal case we cited, talks about there being a difference in the requirements in a reconstruction, that a trial counsel handling the appeal is in far different shoes than the appellate counsel. Now, that may or may not have been the case here. But we had five, if you want to count it, 5.5 motions that were not recorded at all. One of them, I would suggest, was the most critical motion in the case, the Gregg motion. There was certainly great issues put forward in that, or should have been. I don't know. Again, we have no recordation of that. But this was a case where this is a custody battle going on. Parents, one parent was moving out of state. They were in custody over the child. The child makes some gestures that gets interpreted by actually the father's girlfriend. She's taken, she is, quote, according to the testimony, bribed with a sucker and asked leading questions. She then gives a statement. That statement changes again and again over time from...
We do have, in reconstructing that, is Mr. Fern's motion for the Gregg hearing, which is, I think, very comprehensive, typically more comprehensive than many motions asking for a psychological or psychiatric evaluation of a victim. We have that, which is pretty thorough, and we have, obviously, the result of that hearing was denied. Do you have any cases in which we've reversed or handled that question differently regarding a Gregg hearing, a denial of a Gregg hearing where we've said the court abused its discretion?
Barraza said that the court abused its discretion. I mean, and the cases here, this goes from, gee, I was touched, to I was penetrated, my vagina, she said a different word, was penetrated with a knife. I was raped 10 times. I mean, this was an ongoing series of events. He was lurking out, the abuser was lurking outside my window when he was nowhere near the window. It was an ongoing statement, which even an expert for the defense later said, you know, the questioning even done by the expert was leading and inappropriate.
So is it your position, counsel, that when we have a situation where we do not have a verbatim transcript, that even though the parties attempt to comply with the rule on reconstruction, if one or the other party simply has no recollection and so cannot make a meaningful contribution to that reconstruction, we have to assume prejudice?
Well, I think there is prejudice. I think you look at Lambrera, and Stacy says if you have appellate counsel is not trial counsel, there's certainly that issue. But in this case, Your Honor, I don't think we have to go that far because the state, despite Ms. Johnson's effort, could not really say what happened. I mean, here's from her affidavit, which the court adopted, frankly. The court did not come up with its own recollections. It just adopted Ms. Johnson's affidavit. She wrote, quote, I do not have the notes of the court's ruling, but believe that the court found that the defendant did not present a compelling reason for an independent psychological evaluation and denied the motion. That says nothing. This court has to look at whether this was an abuse of discretion. Can it, based on this record? I suggest you cannot. Even if you wanted to become the super trial court and look at these issues and decide whether a Gregg motion should be granted, you can't do that because you don't have the record that was presented to the court.
We do know, though, that there were no witnesses at that Gregg hearing. So we know it is basically a legal argument based on the record that was before the court.
Well, Your Honor, I'm taking everyone's word at that. Again, there's no record to say there were witnesses or not witnesses.
And does that change the fact, because there was no evidence presented?
No, because the court has to go through the requirements of evaluating this testimony as this court, the appellate courts have set out under Price. We don't know what the court said. I accept the conclusion that in the end he says, well, it's not sufficient. But based on what? What did defense counsel argue? What position did the court take? Did it just ignore this evidence? Did it really consider it? We don't know.
We haven't required courts to go through each factor by factor and make findings, though.
Well, but
So what's the difference, really? As long as we know that the issues were before the court and the court made the ruling.
But how do you know? Again, that's just telepathy as far as I'm concerned, is legal telepathy of what the court knew or decided or what was before it. Again, this reconstruction, which is entirely Ms. Johnson's work, if you look at it, is just conclusory. I argued this, he argued what was in the motion, judge found it insufficient, I believe. I mean, and she put that proviso on. We're talking about an individual
It actually goes one step further. Didn't the judge say, I have no recollection of why I ruled the way I did?
Right.
Okay.
He did. He says, here's what I normally would do, but I can't tell you if I did it in this case. And we're talking about an individual with a life sentence here. At a minimum, don't we say that in an issue this isn't an arraignment. This isn't, as the case, a previous case in Kansas, a jury question being asked, though that could be critical too. This is the most critical motion in the case. And there were 4 others that were completely not transcribed. Again, that was only part of the transcription problems. I think we pointed out, this transcript is a disaster. It was never proofread. We brought up how many problems there were with it. We have the court reporter saying the word should be original. I'm sure that's what Ms. Johnson said, but it's urinal in the transcript. There are sentence after sentence, as we pointed out at the end of the reconstruction hearing, that just don't make no sense. They make no sense at all. So that's what we're faced with here. Your question before you simply is, should a defendant who's got a life sentence have a right to have a review of a matter this critical to the case with a transcript so that this court can actually review it, not guess? If I appeared before this court and had not 302'd a portion of the transcript, let's say the Gregg motion, into evidence, what would you do? You'd say it's not here. We're not going to decide this, Mr. Ney, because you didn't make it part of the record.
What's the relief you're requesting?
I'm sorry?
What is the relief you're requesting from this court?
A new trial.
And this would be, what, 5 years after the alleged incidents?
Well, it's 5 years because the court reporter took 3 years to prepare this transcript, but yes. In fact, the alleged incident was in 2006.
And the alleged victim at that time was how old?
She was 3 at the time of the incident. By the time of trial, she was 6. I'd like to move on to one other issue, at least. The court here waived the qualifications of the defense attorney in this case. Under regulations, Mr. Fern was not qualified to try a off-grid felony.
Do we know anything about Mr. Fern's qualifications prior to this waiver, his experience prior to this waiver?
Yes. He did not have those qualifications, yes.
Understand that, but specifically, is there anywhere in the record that points to that?
Yes. The court says, at volume 10, pages 5 through 6, he talks about the regulation on appointed counsel in order to try a case, defend a case that is off-grid, has to have completed the verdict 5 felony trials. He goes on, under that regulation, the court can make a finding that your counsel is competent to handle this case even though he may not have tried 5 jury trials to verdict. So the court is clearly bringing this.
Tried 4.
We don't know. Maybe you tried none, Your Honor. You and I can speculate all day long. You may not even try to misdemeanor.
So does compliance with the, in your view, it's the fact that it wasn't specified or the reason that the exception was taken is the problem here, not that he didn't qualify under the statute?
No, he did not qualify under the statute.
What if Mr. Fern tried a perfect trial in your mind, but the verdict didn't come out the way, but did every single step that he was supposed to do? Is that per se a problem?
Well, it's not per se a problem, but that's not the case here. He did not try a perfect trial. He failed to raise, although he mentions speedy trial, he does not file a motion for inexplicable reasons. He does not renew, although he objects by motion eliminate to Ms. Spaniel, the social worker, testifying and vouching for the complainant here. He doesn't object when she does, and the state has raised both of those as waivers. They say Mr. Fern waived speedy trial because he didn't object.
No, he waived speedy trial.
Well,
If it was an affirmative, I'm not going to not pursue that. He brought it to the court's attention on further investigation, waived speedy trial. And he was present for those objections that were raised, specifically the March 29th objection. He knew what happened. You can't defer to his understanding of his role in that or his client's role.
he talks about filing a motion and then doesn't.
Right, on further investigation.
And again, he doesn't make contemporaneous objection when the witness is vouching for the complainant. Though he filed a motion to eliminate, he does not know he has to make a motion or an objection. When his motion is being violated, she violates it repeatedly, as we pointed out in one of the issues.
Counsel, are you
Yeah.
saying on this regulation that, like in rural southeast Kansas, if you don't have somebody that has the qualified under the rule and had the requisite number of jury trials, that we're going to have to go to someplace in Lawrence, every case, to appoint somebody for one of these cases? Are you telling me as a trial judge, I can't make a finding that this individual is competent? Is that what you're telling me?
No. Regulation says you as a trial judge can make that determination. But you have to make the determination. You just can't say, well, Mr. Fern is a good old guy, and I think he's competent. Again, we don't know whether he's tried a single case to a jury verdict, because there was no record made of that. The court has to make a specific waiver.
So I would have to make a records and go search whatever counties that individual had tried cases in and make a record of those cases? I can't just say that I've had this person there and he has tried cases in front of me and is qualified in my mind?
Right, you can't. That's my opinion, Your Honor, bluntly. The Flynn case was a case where this court said, look, we're going to say the trial judge did this right. He set down the number of cases he had and what he had done. Frankly, if you say, you know, I think this is a good guy, I think he's competent, and he's tried one misdemeanor, I think this court gets to disagree with you. But it cannot disagree with you unless it knows. You have to put that on the record. That's what is contemplated by the statute.
How do we get around the presumption that without an objection, we presume the district court makes all the findings necessary to support its ruling?
Well, who's supposed to object? I think we're in kind of an area here where the defendant is supposed to know enough.
Well, he was asked specifically.
But it's not his waiver. The statute clearly says only the trial judge can make this waiver. The defendant can say, I want this guy all day long. Look at the Spears case. And the court can say, no, you're not getting him because he's not qualified. So that's irrelevant. And frankly, I think the explanation that's given to the defendant is so obtuse. I mean, I don't understand it once the trial judge has done what exactly he's saying. But he has to lay out what the record is. Otherwise, this is meaningless. The regulation might not exist if the judge can say, well, I'm saying these people are fine. I don't think that's acceptable. That's what this regulation, Your Honor, you know, Justice Johnson, I would say was meant to prevent just that sort of appointment process where anybody could have be appointed for any case. And if we go to this, if this is okay, then we've gone back to that standard.
Counsel, I see you're out of time. Would you like 30 seconds to summarize?
I would like 30 seconds to actually.
I have one more inquiry.
Okay.
And
Certainly.
Your questions on and your issue about qualifications, doesn't that really lead to an ineffective assistance of counsel claim?
Well, a statutory claim. Let me be clear, Justice President. There are two separate issues, statutory and constitutional, just like a speedy trial.
I understand.
If we say there's a Sixth Amendment right to a speedy trial, that's a constitutional issue. But there's also a Kansas statutory right to a speedy trial, which is very different and has certain time periods addressed to it, which the statutory does not, per se. We are raising only today the statutory claim that this attorney was unqualified under the statutes and regulations to try this case, and the court never did a proper waiver of that.
So you're incorporating the bids regulation into the statute in Kansas that says you have a right to an attorney at every critical stage of the prosecution.
Well, right, but the statute that we're really talking about says that bid sets, the statute exists, which is bid sets the criteria. Then the regulation is the enactment of that statute, the further enactment of that statute, the bids regulation. So as a regulation, it becomes part of that statute for qualification. Yes.
Any more questions of counsel? We'll still like your 30 seconds to summarize.
I would if I could. I actually wanted to touch on one last thing in 30 seconds if I could, Your Honor, sure. And it can be taken off my rebuttal time if necessary. I think this court has to look at the sentencing issue here too. Clearly the court did not understand its rights to do a departure. It talked about that this had to be a lifetime sentence, that it'd be ignoring the statute, I think the court said. And further, the court refused to consider mitigating evidence in the form of letters that were submitted to the court because of confrontation violations. But, on the other hand, considered victim witness statements, which there was no confrontation right given to the defendant. Thank you.
Three of the five people that letters were denied from, though, did testify at the sentencing.
They did, but their testimony was different from the letters, so the letters were still refused. Again, I don't see that the court later accepted those letters.
But didn't defense have the ability to have asked the questions that were related to the substance of the letters?
Certainly, but we would say, Justice, that even if we leave those three out, there were other letters that were not considered.
Is it preserved in the record?
The letters? Yes.
An objection?
Oh. He tendered them, there was an objection, and the court excluded them. I would say, if you're saying did he make an exception to the court's ruling? I don't think so, and I don't know that
The proffer
actually
was enough.
required.
The proffer was enough to preserve.
Yeah,
is your point.
that would be our position.
Thank you, counsel.
Thank you.
Good morning. My name is Terry Johnson. I'm Bourbon County Attorney. I guess I would like to focus on the two issues that you focused on with Mr. Ney, specifically on the qualifications of trial counsel. I would admit, trial counsel, there is not documentation where the trial counsel went through and said, I'm sorry, not trial counsel, the judge said, Mr. Fern has tried X number of cases or has this experience. I would agree. There is not a record of that.
And what if Mr. Fern had tried one littering case to the court, and that was the sum total?
Well, I would hope that the court wouldn't have said that he was competent
But
to.
how do we review it? We're asked to review.
Right.
And how do we effectively review if we don't have anything to review?
And I don't disagree with you. I understand that the trial judge did not make specific findings for your review. I do think, however, that the cases that Mr. Ney cited, it's more appropriate. It's a 1507 type of question. The cases he cited all came up through that route where a record was fully developed as to what experience the trial court, the trial attorney did have. And so
I'm kind of curious, counsel, if we said yes, 1507 is the appropriate route and we send it back for the district judge to make findings, isn't that the same basic problem we have in this case on the motions because there just is no record of anything? And the judge is going to say, I cannot recall why I felt that Mr. Fern was qualified. And then where are we?
specifically, I think it's the correct route on the qualifications of the trial judge. However, when we go to the motions, I have never had to construct.
If we have on the record here a judge who says a lot of times, I just don't remember what happened, then we're asking that same judge to determine why Mr. Fern was qualified?
That was, I believe Mr. Ney was talking about what trial counsel said in the reconstruction hearing. It wasn't the trial judge saying that. The trial judge did make a statement, one statement that said something like, I can tell you what I would probably have done or would usually do.
But I cannot tell you if I did that in this case.
Right. And then after the hearing, he took it under advisement. He issued his letter order, and in his letter order, he talks about upon further reflection of his own memory. So I don't think you had a situation where the trial judge was repeatedly saying, I don't recall. What Mr. Ney was talking about specifically was the trial attorney. I agree that the reconstruction of a record was very difficult. It's a hard thing to do. I've never had to do that before. The affidavit you have that I prepared and the court adopted is my best recollection of what happened. Mr. Ney categorizes it as self-serving. It's not self-serving. It's my best recollection of what happened. And to go to the point, my recollection is that the court found no substantial and compelling reasons. I don't recall an analysis the court went through of the Gregg factors. And that's why it's not in the affidavit.
This does seem to be a case, though, where at least 2 of the Gregg factors could be applied, and maybe more. How do we know why the court didn't felt those factors were met?
I can't, from my recollection, be able to tell you if the court did make comments or not. I do not remember. And it was difficult. As I'm doing this affidavit, I can tell you I was trying really hard to remember. And I did not have notes of that part. So I think it's very difficult for this court to be able to say that the trial court weighed the factors appropriately or weighed the factors.
And that's the point. I mean, the point is that we can't review because we don't have what we need to review, and the defendant is entitled to a review to find out if he's appropriately sentenced to prison for life. And so what do we do about it?
Well, I think your alternative is the alternative, if the record is not sufficient, is to remand for a new trial. The difficulty with that is, I think Justice Nuss may have asked this. I mean, the alleged victim at the time was 3 of the events. It took 3 years to get to trial. She was 6. And now it is another
5 years later.
5 years
so she'd be
later.
11.
Yeah. I mean, it is a very difficult situation. I am not minimizing that the defendant has a right to have a record that is sufficient for appellate review. And I guess what I'm saying is I don't have any recollection that the court on the record did an analysis of the Gregg factors. My recollection is the judge, after everything was argued, me arguing that she was not consistent, the defense attorney arguing that she was me arguing that she was consistent in her stories, the defense attorney arguing that she was inconsistent, that the court made a finding that he had not presented substantial and compelling reasons.
So, counsel, I guess I'm wondering, are you taking a different position in your brief today? Are you conceding this point that we should send it back for a new trial?
I am conceding, if you believe that or if the court finds that the trial court must make findings regarding the particular Gregg factors or Price factors, I'm indicating to the court, I cannot tell you that the court did that.
As you stand here today.
As I stand here today, I cannot tell you that.
I can
tell you that the court denied the motion finding.
You can tell us what the record already tells us.
Right.
That it was denied.
Do you know why Mr. Fern did not, Mr. Ney explained that he was not in the proper role to file an affidavit or to file a response to your findings or to include any written response? Do you know why he chose not to? Was it simply that he did not recall what happened at the Gregg hearing?
The record shows that the trial court asked each of us, basically, what our recollection was.
Correct.
And Mr. Fern looked at some of his notes and agreed when I talked about what my recollection was, and I had prepared this affidavit already as to, at least in part. And my recollection of the record is that he agreed, yes, that is what happened. For example, on the legal issues, that no further testimony was taken regarding the Gregg hearing, that it was all
They were
legal issues.
They were arguments based upon his motion.
That's correct. And my responses were going right down his motion and responding to his motion and arguing against some of his arguments. So I can't answer that in terms of, I've never asked Mr. Fern that question, but I do know that he was, my recollection of the Gregg hearing was that he was in fact agreeing when I said we argued, for example, based on your memorandum, your motion, we only argued legal arguments. He agreed with that.
So is it your position that we should look at those legal arguments and decide whether or not the trial judge's ruling came out the right way, even though we don't know exactly what the thought process was to get him to the final conclusion?
I would like you to do that. I don't know that that's the standard. The record is what the record is, and it's the best I can tell you as I'm standing here today that I could assist the court in preparing. And I understand the quandary of the court because I don't know how you determine which one of us argued the best, for example.
Can
We're
we
not
get to,
really
oh,
being-
no, go ahead. No.
Before we leave this issue, we're not really being asked to decide whether the judge has to put his reasons on his or her reasons on the record. That's not what's at issue here. It's just the defendant's right to appellate review on a record that's complete enough to facilitate it.
Right.
Okay. Thank you for your candor.
Justice Rosen?
Justice.
Yes, the sentencing issue that was brought up in this case, the district court received letters from defendant's family and relations and declared that he was not going to read them or consider them because those people were not present, or some of them were not present.
Yes.
Is that a typical practice? I'm
We don't
unfamiliar with that tact because
Well, we don't-
letters are all the time considered by trial courts at sentencing. And yes, there might be a confrontation and hearsay problem, but that's not an unusual mechanism to utilize input on behalf of victims, on behalf of defendants or families.
I would say it is unusual in our court to receive letters at sentencing. It's more usual to have people there testifying.
And how do you explain then the discrepancy of allowing letters that were presented on behalf of the state or in support of the, quote, victim in this case, as opposed to denying the same type of information for the defendant? That's clearly what happened.
Clearly, the two statements that I read into the record, one was from the victim's father and stepmother, one was from the victim's grandmother, I believe. I guess from a standpoint of a victim impact statement, those come into the court and are reviewed by the court.
Right.
And so I would equate those to that type of statement.
As that's part of the victim impact statement.
Right.
Except that these really went beyond that, didn't they? These did not focus on, I have seen my granddaughter or my daughter exhibit these behaviors or have these issues. It was more of, this is the penalty that I want. I want you to do life and more if you can, type of thing.
I think that they were expressing their anger over what had happened to their granddaughter and their daughter. So I do think Mr. Holt's actions after he was convicted by jury did impact them and impacted the child, and they were expressing that.
Any further presentation? You have exactly 1 minute left.
I think Justice Ness Johnson, I'm sorry, may have a question.
Change gears on the waiver of bids regulation experience. do you agree that that particular regulation is part and parcel of the statutory right to counsel? You know, we have a statute that says
Right.
you have a right to have a counsel at every critical stage of the proceedings. Does that mean that that right includes counsel that meets the bids regulation? Or is the bids regulation aspirational rather than
Well,
mandatory?
I haven't actually thought about that. However, because case law shows that even if the person wasn't qualified under the statute, that they aren't per se ineffective. I don't know that I believe that the bids regulation becomes part and parcel of the statute.
Any further questions? Any further presentation?
No, thank you.
Thank you, counsel. You reserve 3 minutes for rebuttal.
Justice Johnson, let me turn to what you just asked. The regulation we cited comes from 224522, which in fact says the Board of Indigent Defense Services will, in the most economical manner possible, the constitutionally and statutorily required counsel appoint statutory and constitutionally required counsel. And it then gives them the right to pass these regulations.
What about counsel, though, that's retained? Don't I have a right to retain anybody I want? And if that person is, you know, my cousin Benny kind of comes to mind here. You have someone who comes into town, who just passed law school and is coming in and has no experience at all.
You absolutely do, Your Honor. We've recognized that in post-conviction type litigation. And there's a difference. When I hire somebody, can I claim for post-conviction that they're ineffective? No.
Can you claim they don't even meet the regulations of what the standard kind of protocol is for these type of serious cases?
One presumes that I have a right to question them about their qualifications, their experience, before I hire them. Now, that may or may not be true, but there's a difference we recognize in post-conviction situations, the difference between appointing counsel and what's required and an individual hiring counsel and getting what he gets. Let me just turn for a minute, and I'm sorry. Talks about this was just a legal argument at the Gregg motion, but in the restoration or the recreation hearing, here's what she says. She says, but I do have additional specific, I'm a little hesitant only that I don't want to imply this statement of facts. I disputed every one of the statements of facts. She's talking about Mr. Fern's statement of facts. So they did have a dispute about facts. We don't know how the court came out on those. What if the court, in fact, had said, Mr. Fern, you're right, I think every fact you put in here is true, but I'm denying it anyway? We don't know. Would that not be important for this court's review? And then consequently, the court asked Mr. Fern, do you remember that? And he says, not really, Your Honor, I don't remember that. So, I think that is an issue. Finally, I understand what we're asking here. It is difficult 10 years later, and part of that is because of the court reporter's delays here, but there are other factors as well. It's difficult to say 10 years later should be a new trial. That's an inconvenience to the state. It's an inconvenience to the alleged victim here. But a life sentence is a much more inconvenient sort of situation for my client. I don't think he's asking too much here to have an attorney that meets the qualifications, to have a record to make these appeals. Let's remember something. This was not an open and shut case. The jury hung, could not reach decisions on the rape charges. There were severe questions here. And this Gregg motion could have been the tipping point for that conviction. When you had the state's experts saying this girl suffered from PTSD from her examination, and defense is denied the chance to examine her to see if that's even true, that could be a very critical point. We think that the record here as a whole demands a new trial, and that's what we'd have asked of you. It's bringing the defendant back here to say, let this court now waive Mr. Fern's qualifications at that time, 6 years ago, 7 years ago, I think is meaningless. Does the defendant get to say, well, knowing Mr. Fern, I now do not want him as my counsel? We think remanding it for any of those purposes is meaningless. We thank Ms. Johnson for her candor, but we would ask the court grant the new trial.
Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. That concludes our docket in Pittsburgh, Kansas. Court is adjourned. Thank you all for coming.
Take your ring with us. Take your ring with us.
I'm just going to take my notebook. They'll put the laptop if you want.
Pick your stuff.